So the Subcommittee for Indigenous Peoples of the United States will now come to order. The subcommittee is meeting today to hear testimony on examining Oklahoma v. Castro-Huerta, the implications of the Supreme Court's ruling on tribal sovereignty. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member or their designees. This will allow us to hear from our witnesses sooner and help members keep to their schedule. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record. They are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objections, so ordered. Without objection, the chair may also declare a recess subject to the call of the chair. Hearing no objection, so ordered. As described in the notice, statements, documents, or motions must be submitted to the electronic repository at hnrcdocs@mail.house.gov. Members physically present should provide a hard copy for staff to distribute by email. Please note that members are responsible for their own microphones. As with our fully in-person meetings, members can be muted by staff only to avoid inadvertent background noise. Finally, members or witnesses experiencing technical problems should inform committee staff immediately. I would also like to thank the ranking member so that the change of time so that we could try to get the testimony in, considering the votes we'll be having this afternoon. I will begin by recognizing myself for my opening statement. Good morning, and thank you all for joining us today at this important oversight titled Examining Oklahoma v. Castro-Huerta, the Implications of the Supreme Court's Ruling on Tribal Sovereignty. As many remember, the 2020 landmark U.S. Supreme Court ruling in McGirt v. Oklahoma recognized that Congress had never disestablished the Creek Reservation in eastern Oklahoma, reaffirming that it remained Indian country. The McGirt ruling was a victory for tribes across the country as it indicated the court's commitment to upholding treaty rights through historic legal precedent. Unfortunately, 2 years later, the court's ruling this summer in Oklahoma v. Castro-Huerta now serves as a sharp contrast to the McGirt ruling. In a 5-4 majority opinion, the court determined that state governments maintain inherent concurrent criminal jurisdiction over Indian country. More important for many, the Castro-Huerta case overturned almost 200 years of precedent that I learned as the Marshall Trilogy. I learned this when I first started practicing law because it is seen as the bedrock foundation of Indian law. I don't know how many times I cited the trilogy in my cases. Roosterville, Georgia, the third case in the trilogy, was decided in 1832, which, as Justice Gorsuch stated in his dissent, established the foundational rule that Native American tribes retain their sovereignty unless and until Congress ordains otherwise, close quote. The Marshall Trilogy of cases underpine not only recognition of tribal-state criminal relations, but many other foundational legal precedents governing tribal-state relationships in a wide range of circumstances. It's often cited not just for criminal law, but also in fact, sometimes more often, in the civil context. So the Castro-Huerta case understandably sent shockwaves across Indian country and in the legal community, which understood its potential vast implications. The missing and murdered Indigenous women and people crisis, the aftermath of the McGirt case, and many other examples of the federal government's failure to recognize its trust responsibilities to investigate and prosecute crimes in Indian country are rooted in the federal government's failure to adequately fund and prioritize the safety of tribal communities. Castro-Huerta has broad implications for Indian country, implications that vary deeply amongst tribes. Until Castro-Huerta, states were largely excluded from Indian affairs unless Congress provided otherwise. Today, we are here to listen, to learn what this decision means from tribal leaders, from the administration, and from experts in the field. This is the beginning of our discussion on Castro-Huerta. This hearing is not to advocate a particular solution or a particular piece of legislation. It is meant to better understand the nuances and impacts of the decision. The court's expansion of state criminal jurisdiction may add greater uncertainty over whom tribal citizens may or should call in response to a public safety emergency, what police force may be allowed to respond, and what authority tribes and tribal victims may look to prosecute a case. Prior to Castro-Huerta, existing jurisdictions in Indian country were already complicated. The standard framework consisted of the federal government maintaining criminal jurisdiction alongside tribal governments depending on the offenses committed, the legal status of both the victim and the offender. Exceptions to the framework, such as Public Law 280 states, existed, but importantly, though, Congress, not the Supreme Court, enacted those exceptions. Congress retained the authority to decide how and when the state was authorized to operate within tribal lands. So Castro-Huerta has complicated this existing patchwork of jurisdictions by adding in state authorities, leading to uncertainties that I discussed earlier. Tribal governments already face a variety of public safety crises. Some of those issues we have discussed in this committee. There's concerns about the murdered and missing Indigenous people crisis being one, the lack of jurisdictional authority to respond or prosecute because of Oliphant, and just the lack of resources for their judiciary branch and their police branches. We know that the precise impacts of this case will look different for each tribe. That's why it's important for us to have this hearing today. Our witnesses hail from across the country and represent different legal perspectives as well as different legal nations. I'm grateful that we will hear testimony from the Cherokee Nation, where the Castro-Huerta case originated, and from another Oklahoma tribe, the Muskogee Creek Nation, where the McGirt decision originated. Supreme Court cases rarely confine their impact to the jurisdictions where they originate. Indeed, the Supreme Court's decision to take a case often is precisely because of the national impact. Tribes in PL 280 states and tribes in non-PL 280 states who have fought intense battles within their states to protect tribal sovereignty from state intrusion are also present here today. We'll hear finally also from legal experts and in our first panel from the administration about the impacts that Castro-Huerta may have in Indian country and more broadly. Once again, I look forward to this discussion. I want to again thank my witnesses for their presence here today to share their expertise. And I would now like to recognize Ranking Member Obernolte for his opening statement.
Thank you very much, Madam Chairman. And thank you for convening this hearing on what is really an extremely critical topic, the topic of whether or not states have criminal jurisdiction to prosecute crimes committed against Indians by non-Indians in Indian country. This Huerta decision really has the potential of attacking tribal sovereignty in a lot of different parts of the country. Certainly reaches far beyond just the territorial dispute that's going on in eastern Oklahoma. I think that a couple of things should guide our discussion when we're talking about this important topic. First of all, the respect for tribal sovereignty, which I think is something that everyone on the subcommittee shares, but also a conviction to avoid the kind of legal chaos that resulted after the McGirt Supreme Court decision. We had thousands of cases that were refiled in tribal and federal courts after that on criminal convictions that had occurred years in the past. So I think it's important that we think about the implications of decisions that we might make in that respect. And I'd also like to ask that we consider the feelings and the well-beings of the victims of these crimes and of their families. Because when we allow a criminal case to be retried, we are essentially dragging all of those victims and their families through what for many of them was the worst experience of their life. So I'm hopeful that we can remember those victims when we have this discussion. And I also would like to make the point that all of this legal chaos from McGirt all the way to Castro-Huerta could have been avoided had Congress done its job. Our job as lawmakers is to be explicit when we write laws. And because of the ambiguity that has persisted surrounding this issue, we're having courts issuing conflicting opinions in different jurisdictions, which is exactly the kind of thing that a nation who respects the law, the rule of law, should be trying to avoid. And if you look at the Castro-Huerta decision, it's really a fascinating exercise in exactly this problem, because you've got Supreme Court justices on both sides of the issues making what seem to be very legitimate and well-reasoned arguments that completely contradict each other. So I'm very glad we're having this hearing. I'm hopeful that perhaps this can catalyze Congress to be explicit about what its intentions are towards the prosecution of crimes in Indian country, and explicit about what the boundaries of reservations are, which could have avoided the chaos of McGirt, and whether or not states have, what exactly the jurisdictions of states are to perform these criminal prosecutions, which could have avoided the chaos that we have in Castro-Huerta. So I want to thank all of the witnesses that we have here today. I think this is exactly the right way to go about having this discussion, is to start by listening to the people who would be affected. I also am glad that we're being deliberate, because obviously it's only been 12 weeks since the Supreme Court decision was handed down. I think it's going to take some time for Congress to process this issue, but I'm hopeful that at the end of this discussion, we can come up with some concrete rules that will clarify this issue for everyone, which would be Congress doing its job and not allowing throwing it open to interpretation by the courts, which I think is something that should be avoided. So I want to thank you, Madam Chairman. I yield back.
Thank you very much, Ranking Member Open-Nolte. Now I'd like to transition to our first witness panel for today. Under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down, and it will turn orange when you have 1 minute remaining. I recommend that members and witnesses joining remotely lock the timer on the screen. When you go over the allotted time, I will tap my gavel and kindly ask you to please wrap up your statement. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. The chair now recognizes the Honorable Brian Newland, who is the Assistant Secretary for Indian Affairs at the U.S. Department of the Interior. Assistant Secretary, the floor is yours.
Thank you, Madam Chair, and good morning, Ranking Member and members of the committee. My name is Brian Newland. I have the privilege of serving as Assistant Secretary for Indian Affairs at the Department of the Interior, and I appreciate the invitation and the opportunity from the committee to appear here this morning to share our views on this important case. Throughout the history of this country, criminal jurisdiction in Indian country has proven to be quite complex. A number of variables determine whether a tribe, the federal government, or the state have jurisdiction to prosecute crimes committed in Indian country. These include the tribal affiliation of the offender, the tribal affiliation of the victim, as well as the land status of the crime scene. Any change in one of these variables will change who exercises criminal jurisdiction. And this complex maze was developed largely through judicial decisions, and it's made it difficult for tribal governments to police tribal communities. Congress, working with the executive branch and tribes, has legislated to clarify criminal jurisdiction in Indian country. And in the past half century, the trend in these statutes has been to affirm tribal sovereignty and to strengthen the ability of tribal governments to protect communities in their reservations. In fact, Congress has acted on at least seven different occasions in the last half century to strengthen and affirm tribal criminal jurisdiction within Indian country, often in response to Supreme Court decisions. The court's decision in Castro-Huerta, for the first time in the history of this country, gave states criminal jurisdiction over crimes committed against Indian people by non-Indians within every reservation in every state. The Castro-Huerta opinion creates uncertainty across Indian country. State prosecutors may now accept or decline cases involving crimes committed by non-Indians against Indians in Indian country without getting the consent of the tribe. This invites further conflict, and it diminishes the ability of tribes to coordinate with federal agencies on public safety priorities within their communities. The department is reviewing the effects of this decision in determining how to further our trust obligations to protect tribal sovereignty, self-determination, and how to strengthen tribal jurisdiction. Centuries of interactions between tribes and states have shown that a delicate relationship exists between the two. Under Public Law 280, we've seen the difficulty of concurrent federal and state jurisdiction in Indian country. Tribes in PL 280 states have repeatedly told the department that state resources don't always make it to their communities. Many tribes have built up their own law enforcement capacity and have successfully retroceded from Public Law 280, reinstating concurrent federal and tribal jurisdiction. Castro-Huerta not only disrupts the process that Congress established for allocating criminal jurisdiction between tribes and states, but it has the potential to spread these challenges to tribes located in non-Public Law 280 states. Tribes have repeatedly proven that they can best meet the public safety and justice needs of their reservations. Congress has agreed and has affirmed the principle of tribal self-determination repeatedly in the last half-century. In the 2013 and 2022 VAWA reauthorizations, Congress created a path for tribes to exercise criminal jurisdiction in certain cases over non-Indians. And it's a federal trust obligation to assist tribes in meeting VAWA standards for expanded criminal jurisdiction. It's also important to note that Congress has paired its legislation affirming tribal jurisdiction and sovereignty with increased investments in tribal law enforcement agencies and tribal courts. This includes an additional $62 million in funds to support tribes in Oklahoma after the McGirt decision. Recent increases in funding have strengthened federal and tribal law enforcement capacity across Indian country. Next week, the Department of the Interior and the Department of Justice are hosting 2 listening sessions with tribes to discuss the Supreme Court's Castro-Huerta decision. We're seeking comments on a number of questions related to the outcome of the case. As trustee to tribes, the department will continue to prioritize and reinforce tribal sovereignty, tribal self-determination, and tribal jurisdiction to ensure public safety can be realized across Indian country. So, Madam Chair and Mr. Ranking Member and members of the subcommittee, I want to thank you again for the opportunity to be here today to provide the department's views. I'm happy to answer any questions you may have.
Thank you so much for your testimony here today. And I'm going to remind members that the Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask the witness. I will start by recognizing myself for 5 minutes. Thank you again, Assistant Secretary. This is the second time you've been before the committee in less than a week. We know we have a lot to cover. So I wanted to pick up on the statement with regards to VAWA, and Congress did give tribes additional authority to prosecute in those cases, right, which are, we have heard, and some of the testimony we believe we'll be hearing later today points out that in some states, they've already decided, or at least this was out of Oklahoma, that they are not being referred, that the tribes aren't getting referrals of our cases of abuse against children, of abuse against women. What have you heard out there regarding the immediate impact from the Castro-Huerta case in terms of those referrals, which I think are key because, as you pointed out, tribal leaders, tribal government is the closest to the family, the woman, the children that are being impacted.
Thank you, Madam Chair. The main thing that we've been hearing in light of this case is confusion and stories about the potential to create more conflict in public safety in Indian country. Prior to serving in this role, I served as elected tribal leader and also as a tribal court judge. And tribal officials are often charged with setting policy for their communities on the reservation. And just like state legislatures and just like Congress, that's always based on conversation and feedback from constituents. And in light of this case now, we see the ability of states to come in and exercise jurisdiction over cases like this without tribal consent. And so it disrupts the ability of tribal officials to set the priorities, the public policy priorities within their reservations. And it removes the leverage that they have to cooperate with their neighboring communities and neighboring jurisdictions. So the themes that we've been hearing after this case are confusion and the potential for this case to invite more conflict.
That's interesting, the point you're making about that what we want to see is more opportunity for collaboration and cooperation. I mean, we've seen that whenever different law enforcement agencies cooperate, federal, state, tribal, federal, state, local, it's the cooperation that often leads to the breakthrough, because a perpetrator is not necessarily going to stay within one jurisdiction. So you're saying that the worry is that this will not, rather than enhancing it, it will undermine. Is that correct?
That's correct.
Can you share with us, I do look forward to receiving feedback on your listening sessions. I'm glad that we are all engaged in determining what the impacts are. But can you share with us any thoughts that the department has with regards to providing additional law enforcement support and resources to tribal governments, and how that might have changed your calculus after Castro-Huerta?
Thank you, Madam Chair. We have been working with Congress and with Indian country to increase funding for public safety across Indian country and within tribal communities. In my work in this role, far and away the number one thing I hear from tribal leaders is about the need to do better in working together on public safety issues in tribal communities. That's been a consistent theme no matter where I've visited in every region of the country. And so we've been working again with Congress to increase that funding, to increase resources to tribal governments, and to also support them in the exercise of their criminal jurisdiction to ensure safe communities.
Thank you. And in this listening sessions that you're going to be doing, will you be conducting those as official government-to-government consultation or as listening sessions?
Madam Chair, these are titled listening sessions, and the distinction will allow us to hear also from scholars and legal advocates, as well as tribal leaders. Of course, we always want to engage directly in a government-to-government relationship, and that will be a part of these listening sessions.
And I take it that after the listening sessions, have you already begun the work to provide guidance to tribal governments following Castro-Huerta?
We have not. We want to hear from Indian country first, and of course, we have to work together with the Department of Justice before proceeding.
Well, I believe we all want to hear from the Department of Justice as well, and we look forward to having that opportunity in the future. So thank you very much. The chair will now recognize the ranking member.
Mr. Newland, it's very nice to see you again. It's only been a few days. It's great that the DOI is taking the step of conducting these listening sessions. I wonder if you could fill us in on what contacts you've had from tribes outside of Oklahoma who are concerned about how the Castro-Huerta decision changes the jurisdiction of state prosecution of crimes.
Thank you, Congressman. We have had meetings with tribal leaders from different regions of the country. In particular, we've had representatives from the Great Plains Tribal Chairmen's Association tell us directly that they are worried about the impact of this decision and the potential for confusion in policing in their communities.
And have you had contact with states that are now interested in pursuing criminal cases in Indian country? I mean, outside of the public law 280 instances that already exist?
I have not, no.
So you obviously have a lot of experience in this issue. You have a good grasp of the cases, the decisions, and their implications. Wondering if you could advise us in Congress as to what actions Congress should take in response to the Castro-Huerta decision. What would you advise us to do?
Thank you, Ranking Member. Before I go so far as to recommend a path forward, I want to make sure we get feedback from Indian country. But on the whole, I think, as we've tried to show in our testimony, we've had now since the self-determination era, Congress is led by both parties, administrations from both parties have been very consistent in affirming the principle of self-determination and tribal sovereignty, and Congress has acted consistently to clarify and strengthen tribal jurisdiction within their boundaries of tribal reservations. And so it would be in keeping with that trend and with the policy of self-determination for Congress, as you indicated in your opening remarks, to clarify and strengthen the ability of tribes to determine how public safety is protected in tribal communities. And the hallmark of that is consent. And that's a law that Congress has already enacted more than 50 years ago, is to ensure that tribes have the ability to provide consent when other jurisdictions are acting within the boundaries of their reservations.
Okay, so the issue of consent, I mean, I think that's a great one. I mean, that really we already have that, right? Because when a tribe consents to have states bring criminal prosecutions on Indian country, that's a completely different situation to a tribe that might want to try those cases itself. So how would we, in Congress, how would we act? What action would we take to strengthen the ability of tribes to consent and to protect tribal sovereignty in cases when they do not wish to?
Again, Ranking Member, as part of our trust responsibility, I want to make sure that we are working with Indian country to present solutions. So I don't want to offer up specific solutions to the subcommittee without first hearing from tribes. And I also want to make sure that when we do that, we have the Department of Justice at the table. They're going to be participating in these listening sessions. But I think on the whole, again, Congress has been consistent in acting, many times in response to the Supreme Court, to defend its prerogative here to set the federal government's Indian affairs policies, and in doing that has worked with tribes and has worked with the executive branch in fulfilling those obligations.
Right. Well, I completely agree with you on both of those issues. I do think that Congress needs to act deliberately, not immediately, but deliberately, and I applaud you for how thorough you've been in soliciting the input of everyone involved, and I think the DOJ also needs to be at the table. And I also think that you brought up a very important point, which is the protection of people should be at the forefront of the decisions that we make. And the worst thing that can happen is that crimes go unprosecuted. Crimes against Indians in Indian country go unprosecuted. That's unacceptable. We absolutely cannot allow that to happen no matter what we do. But I hope that the end of this process is Congress chooses to act, we do it deliberately, we do it fairly, and we do it explicitly so that we don't throw open the interpretations of the actions of Congress to the courts, which I don't think serves anyone interest. I want to thank you for your testimony. I yield back, Madam Chair.
Thank you. The chair will now recognize the gentleperson from Arizona, Representative Gallego.
Thank you, Madam Chair. I want to start by thanking Chair Legislador Fernandez for calling this hearing and by thanking our witnesses, especially the tribal leaders, for testifying. Unfortunately, we're here today to examine yet another blow to tribal sovereignty in the form of the Castro-Huerta Supreme Court decision. On this subcommittee, we spend much of our time writing past injustices and working towards a future where the federal government finally fully lives up to its trust responsibilities. The Castro-Huerta decision makes this task even more difficult by undermining tribal sovereignty and unraveling hundreds of years of precedent around criminal jurisdiction in Indian country. Part of the court's motivation for this decision appeared to be that upholding tribal sovereignty in this case was an inconvenience. But we on this committee know that upholding the trust responsibility isn't about convenience, it's about complying with the treaty obligations the United States is legally bound to do. That's why I believe Congress must act swiftly to address Castro-Huerta before it's more harmful and its disruptive impacts can come to pass. I look forward to today's hearing from tribal leaders directly about what they believe Congress's next steps should be in the wake of Castro-Huerta. With that, I have a couple questions for our witnesses. Assistant Secretary Newland, I appreciate that your written testimony spoke not only about clarifying the jurisdictional issues raised by Castro-Huerta, but also ensuring that tribes have the federal support to build capacity for law enforcement and self-governance on their own land, a key element of combating the missing and murdered Indigenous persons crisis. That's why later this week, I'm planning to reintroduce the Badges for Native Communities Act. The bill would support hiring personnel and resolving unmet needs for law enforcement in Indian country. How is your department working to help build this capacity in Indian country, especially post-VAWA reauthorization?
Thank you, Congressman, and it's great to see you again. Secretary Holland is passionate about this issue and has been forceful in directing us to work with the Department of Justice and under President Biden's executive order on public safety in Indian country, coordinating across agencies. And we know data is a key component to make sure that we have effective policing. And so through the Not Invisible Act Commission and existing statutes that Congress has already enacted, we've been working with the Department of Justice to make sure that we're bridging those data gaps.
Follow-up question. There's a concern that Castro-Huerta's determination of concurrent state jurisdiction over major crimes committed in a country will cause the federal government to pull out its law enforcement forces on tribal lands. Does the department plan on doing this, or have you heard of this concern?
No, we don't plan to do that.
Has there been any concern expressed by some of our tribal leaders in terms of, have they expressed that concern to you?
Not to me directly, Congressman. We don't have plans to pull out of Indian country and let tribes fend for themselves on this. And I'll defer to the tribal leader witnesses to share their views on that.
Thank you. And just Assistant Secretary, just from my experience visiting tribal lands and visiting with our tribal law enforcement, there is just a backlog, even just in terms of tribal infrastructure, in terms of law enforcement buildings, for example, jails, prisons, as well as, of course, how hard it is to recruit these police officers to come and serve these communities that sometimes are far away from metropolitan areas. And so, of course, just want to make sure I highlight that, because they want security just like they want and deserve security just like anybody else. And these types of court decisions really, I think scares a lot of people in thinking that may not happen. So with that, thank you, Madam Chair and Ranking Member for hosting this.
Thank you very much. The Chair will now recognize the gentleperson from the American Samoa, Representative Radhawagan, for 5 minutes. Hello.
Thank you, Madam Chair. My question is for Mr. Newland as well. There have been some who proposed ambitious legislative proposals, and that action should be taken immediately. Yet there are some tribes that have voiced restraint, and they're concerned about Congress acting too quickly. What are your thoughts on the lack of a unified position from tribes in Oklahoma and tribes throughout the United States?
Thank you, Madam Congresswoman. I think it's important to affirm at the outset that while this case originated in Oklahoma, it is not confined to Oklahoma. That's why we are soliciting the views of tribal leaders and tribal attorneys and scholars across Indian country on the best way to move forward. I think that there needs to be deliberate and thoughtful action, but of course with 576 federally recognized tribes, there's rarely uniformity on any one view, but it's going to be important that we get as much feedback as possible before recommending a path forward.
Thank you, and I yield back the balance of my time.
Thank you very much. Are there any other members who wish to ask questions who have not asked questions? Seeing none, I'd like to thank you very much for your testimony. We look forward to hearing feedback on your listening sessions and to continuing this conversation so that we can have deliberate but actual congressional response. We'll now move on to our second witness panel. We'll be transitioning to our second panel of witnesses today, and as they take their seats, I will remind non-administration witnesses that they are encouraged to participate in the Witness Diversity Survey created by the Congressional Office of Diversity and Inclusion. Witnesses may refer to their hearing invitation materials for further information. Under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down and will turn orange when you have 1 minute remaining. I recommend that members and witnesses joining remotely lock the timer on their screen. When you go over the allotted time, I'll tap my gavel and kindly ask you to please wrap up your statement. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will allow the entire panel to testify before we begin the question portion of the hearing. The chair now recognizes the Honorable Jonadev Jauhuri, who is the ambassador for the Muskogee Creek Nation.
To testify on the impacts of Castro-Huerta, which are already manifesting themselves in numerous ways across all of Indian country. My name is Jonadev Chowdhury, and I'm proud to serve as the ambassador for the Muskogee Creek Nation, the fourth largest tribe in the United States. I'm joined today by our Attorney General, Jerry Wisner, who is available to answer any questions here today or in QFRs related to public safety on our reservation. Castro-Huerta requires immediate action. The risk of misapplication of the holding, either by the courts or important federal agencies, is very high, and as a result, we need Congress to immediately signal its ongoing intent to adhere to honor its treaty and trust responsibilities. As Justice Gorsuch noted in his dissent, when the founding framers drafted the Constitution, they took care to eliminate state power over tribes within their borders. The founding framers also saw fit to declare treaties, once signed by the President and ratified by the Senate, to be, quote, the supreme law of the land. The Constitution then tasks Congress with the exclusive role of managing relations with tribal nations. As the Muskogee Creek Nation, we signed the very first treaty entered into under the Constitution as we know it today. In 1790, President George Washington gathered with Muskogee leaders to sign the Treaty of New York. That treaty delineated the boundaries of the fledgling United States, as well as the duties, responsibilities, and obligations of the United States to my nation. The decision in Castro-Huerta dangerously infringes on Congress's ability to effectuate its treaty responsibilities and obligations to tribal nations. In the modern era, Congress has, in a consistent, bipartisan manner, steadily worked to restore tribal sovereignty and secure tribal empowerment. From the Indian Reorganization Act in 1934 to the Indian Child Welfare Act in 1978, from the 2010 Tribal Law and Order Act to the 2013 and 2022 reauthorizations of the Violence Against Women Act, Congress's message has been clear. The best and only real solution to addressing public safety in Indian country is restoring tribal jurisdiction and sovereignty. Castro-Huerta undermines tribal jurisdiction and sovereignty by creating a false narrative that Native victims are best protected by the state. They are not. And now, post-Castro-Huerta, there is no law or mechanism requiring local county law enforcement agencies to inform tribal nations when they learn of crimes committed against Indian victims, even if the county agency ultimately declines to prosecute. We are already receiving alarming reports that county officials are reluctant to do so. We will simply have no way to know about the crimes that are not being prosecuted. This is precisely the public safety crisis Congress sought to avoid by passing VAWA 2022. And although I know other voices testifying here today may tell you Castro-Huerta was necessary to address a public safety crisis, any actual crisis was entirely manufactured by the individual county sheriffs, prosecutors, and others who have not only refused to collaborate, but actively used criminal cases, and most disgustingly, victims, as political proxies to create the illusions of a crisis. The solutions to Castro-Huerta are clear. They're not new. Over a decade ago, the Tribal Law and Order Act Commission, created through bipartisan legislation and composed of bipartisan legal experts, traveled throughout Indian country studying the public safety crisis and reported one overarching solution: restore tribal jurisdiction and authority. The solution to the problems created by Castro-Huerta is not to study a problem we already understand. The solution is restoration of tribal jurisdiction and authority, plain and simple, including the removal of outdated, misguided limitations imposed on the ability of tribal nations to ensure criminals receive sentences commensurate with the seriousness of the crimes they commit. Following our victory in McGirt, the state spent millions, tens of millions of dollars to file over 30 CERT petitions and hired multiple PR firms to create the perception that McGirt created a public safety crisis. And as The Atlantic reported in an article published on April 26, 2022, the numbers backing up Oklahoma's public safety crisis claims have been nothing but hyperbole. The court's decision in Castro-Huerta constitutes an outcome-determinative decision designed to appease one governor's misleading and false PR campaign against tribal sovereignty. The decision, however, has implications that extend far beyond Oklahoma. As the nation that has fought to preserve Indian country's historic victory in McGirt, we understand what's at stake when states attempt to usurp Congress's exclusive management of Indian affairs. The court's misreading of the General Crimes Act and disregard for clear congressional intent only fans the flames of an already existing public safety issue throughout all of Indian country. We're asking Congress to take action. Mado, available to answer questions.
Thank you very much for your testimony. The chair now recognizes the Honorable Kevin Killer, who is the president of the Ogallala Sioux Tribe.
Thank you, Chairwoman. Almadakiapi, Makai, Kilia, Hime, Chante, Washte, Nape, Chuzapelo. That's our traditional greeting, Lakota. Shake your hand with a warm and good heart. My Lakota name is Close to Earth. English name is Kevin Killer, and I'm the president of the Oglala Sioux Tribe. Thank you for the opportunity to testify about the Supreme Court's Castro-Huerta decision. This decision held for the first time that states have criminal jurisdiction over crimes committed by non-Indians against Indians in Indian country. This extension of state jurisdiction in Indian country without tribal consent is an affront to tribal sovereignty and a violation of our treaty rights, which Congress can and should rectify by legislation. With the exception of PL 280, the legislative and judicial history of the United States shows the effort by both tribal governments and federal government to keep states out of Indian country. Indian tribes have a government-to-government relationship with the United States. As for my tribe, we entered several treaties with the United States. Our treaties have long addressed matters of jurisdiction to resolve disputes and address those who would encroach on the rights of the tribe or our citizens. In particular, our 1868 treaty says, if bad men among whites were subject to the authority of the United States shall commit a wrong on the person or property of an Indian, the United States will proceed at once to cause the offender to be arrested and punished in accordance with the laws of the United States. Our treaties do not allow the state to come on our reservation and apprehend and take non-Indians accused of committing crimes against a tribal member or other Indians or the Indian on the reservation, then try that person before a non-Indian jury. And South Dakota's Enabling Act and Constitution says that Indian land shall remain under the absolute jurisdiction and control of the Congress of the United States. The majority in the Castro-Huerta decision was solely focused on one particular state in developing its decision. We reiterate that the majority got it wrong, but we also make it clear that Castro-Huerta is a violation of our treaties, which per Constitution are the supreme law of the land. It also violates the tribal consent provision of the Indian Civil Rights Act. We support Congress stepping up to rectify this poor decision for all tribal nations. The Castro-Huerta decision gives rise to major areas of practical concern in Indian country, including, number one, a potential lack of prosecution of non-Indians in Indian country, generally as the state and federal prosecutors point the finger at each other. Two, the potential for chaos arising from conflicting tribal, state, federal laws regarding different standards when charging and prosecuting crimes. Three, the potential application of Castro-Huerta to civil matters and efforts to extend state policymaking onto tribal lands. And finally, four, unending and costly litigation about the application and reach of the decision. Castro-Huerta adds the maze of criminal jurisdiction in Indian country, which complicates the prosecution of crimes in Indian country. The solution to this jurisdictional maze is not to grant unconstitutional powers to the states. Instead, it is to fix jurisdictional gap following the court's decision in Oliphant, which held that tribes lack criminal jurisdiction over non-Indians. Any such fix must include the funding required to carry out that authority. With this, the Oglala tribes ask Congress to, one, repeal all existing civil and criminal jurisdiction limits on tribes and allow tribes the option of fully asserting their inherent right for civil and criminal jurisdiction through our territories, to provide adequate appropriations to tribes to develop our court, law enforcement infrastructure throughout Indian country. If Congress chooses not to address the jurisdictional gaps following the Supreme Court's decision in Oliphant at this time, it should, at a minimum, restore the pre-Castro-Huerta decision status quo by clarifying that states lack criminal jurisdiction over crimes committed by non-Indians. Thank you for holding this hearing, Madam Chair. The Oglala tribe stands ready to work with you to help right the ship on this criminal jurisdiction in Indian country, and will stand by for questioning. Wopila, thank you.
Thank you very much, President Killer, for your testimony. The chair now recognizes the Honorable Cheryl Andrews Maltese, who is the chairwoman of the Wampanoag tribe of Gayhead Ukina. You're now recognized for 5 minutes.
Thank you, and good morning, Madam Chairwoman and member of the committee. Thank you for the opportunity to testify on the impacts of the Castro-Huerta decision. My name is Cheryl Andrews Maltese, and I'm the chairwoman of the Wampanoag tribe of Gayhead Ukina, located on the island of Martha's Vineyard off the coast of Massachusetts. I'm currently serving in my 4th term. My tribe is part of the great Wampanoag Nation, known as the People of the First Light. We've occupied our lands and our homeland since time immemorial. Our ancestors were the signatories to the first treaty in this hemisphere, the 1621 Treaty of Peace between the Wampanoag Nation and King James I of England. This treaty recognized and respected the sovereignty of our 2 nations to govern ourselves. Like other tribes who were among the first tribal nations to encounter European explorers and settlers, we endured centuries of warfare, disease, loss of our Aboriginal lands, discrimination, and forced acculturation. However, like so many Indigenous peoples of the United States, we maintain our culture, heritage, and our tribal government. However, 4 centuries later, we find ourselves still struggling to retain and regain our rights and sovereignty that we freely exercised before the settlement of the colonists, the atrocities of colonialism, and before the establishment of the United States. The erosion of tribal sovereignty and our rights has led to unimaginable crimes perpetrated against us. No one was protecting our vulnerable populations, not even us, because we were stripped of that right. It's been a free-for-all for non-natives to commit crimes against us because no one would prosecute them. Up until the passage of the TLOA, the Tribal Law and Order Act in 2010, non-native perpetrators essentially got away with any crimes they choose to commit against our people in our homelands. And after years of fighting for inclusion, in 2013, Indian country was finally included in the Violence Against Women Act, in order to have standing to begin to have criminal jurisdiction over non-Indians who committed crimes against Native women and children. Think about it. We've only had the ability to actually prosecute our vulnerable citizens for 9 years, less than a decade. Do we now go back so non-natives can come onto our homelands, commit horrible crimes against us, and we have no recourse? Who except for us should be protecting our people? It's tantamount to going back to the 1600s when our women were raped and murdered, our children were stolen from us and often sold off, and what would be now considered child trafficking. How long do we as Indigenous people of these lands have to pay while the privilege hurt our people and take our lands, resources, and our rights again? If this isn't fixed, do we go back to sitting by to wait for help? Help that we don't necessarily need if we were assured the jurisdiction we were entitled to exercise as sovereign nations. We know how to protect our people. We've always had our own traditional forms of justice. We know how to protect the public. We have competent professionals within our tribal governments, as in our case with regard to public safety. We know how to write and enforce building codes, public safety ordinances, and regulations. We have the capacity to protect our people and others who choose to come into our homelands. We don't need another layer of bureaucracy to add to an already complicated system. All we need is the state and local jurisdictions to get out of our business and out of our way. Otherwise, where will the erosion of our tribal rights and sovereignty end? Like a Marshall Plan for Indian country, the United States owes us both the financial and human resource support for us to rebuild our tribal nation. We've paid dearly. We've paid it forward with the lives of our ancestors and our lands and natural resources. We're owed the right to self-determination and self-governance. If you went to any other country or any sovereign lands and committed a crime, you are subject to their laws. If you are processed through their legal system. If you engage in trade and commerce or construction, you're subject to their laws. Every sovereign government has the right to provide for the safety of its people and the public who choose to enter our lands. Are we to believe that Congress feels that we are so much less worthy, inadequate, or incapable of performing the governance and jurisdiction we've exercised since time immemorial? Without clear and unambiguous laws that articulate tribes are sovereigns, nations with the right of full jurisdiction and governance over ourselves, our people, and others who come to our land, there is and will continue to be conflict. These bad court decisions allow states to interpret silence or ambiguity as a void of our rights and authority, and they feel empowered to fill over the rights of tribes which they do not have. Only Congress can fill that void. The erosion of our jurisdiction and the erosion of our sovereignty is just another breach of the United States trust and treaty obligations to us. States and local municipalities do not and should not have any role or oversight in jurisdiction in Indian country. To dilute any tribe's sovereignty and jurisdiction is to dilute all tribes' rights and sovereignty and jurisdiction. We were here as thriving sovereign nations when the Pilgrims landed. And while some on the Supreme Court may have forgotten this important fact, as Justice Gorsuch stated, the ball is back in Congress's court. And so we urge you to lead this body back to the principles that respect tribal governments, tribal rights, and tribal sovereignty, and codify them in federal law. Thank you for your commitment into seeing justice in Indian country, and thank you for the opportunity to testify here today. I'm available to answer any questions if you have any. Thank you.
Thank you very much, Chairwoman Maltese, for your testimony. The chair now recognizes the Honorable Whitney Gravel, who is the president of the Bay Mills Indian Community.
Thank you, Madam Chair. Ani Bojo, Giwede Nagabo Kwe Indishnakas, Ganushnakani Nindonchaba. My name is the woman who stands in the north. My English name is Whitney Gravel, and my voice first sounded at Place of the Pike, also known as Bay Mills Indian Community, which is an Ojibwe tribal nation located on Lake Superior in Michigan's Upper Peninsula. Bay Mills Indian Community has signed multiple treaties with the United States, and in 1936 was federally recognized and has maintained civil and criminal jurisdiction with the federal government on behalf of its citizens. I am appearing before the subcommittee in my capacity as president to speak on behalf of the questions, concerns, and issues we have already encountered due to the United States Supreme Court ruling in Oklahoma v. Castro-Huerta, and encourage the United States to work together to resolve the issues presented by this ruling. As discussed by others providing testimony today, the Supreme Court in Castro-Huerta caused reverberating shocks throughout Indian country as it overturned long-held legal precedent. Without question, it is important to start with the premise that any tribal nation's first duty, since time immemorial, has always been to protect and safeguard our citizens, our people. A crime against one person is an offense against the people and the sovereign laws of our government. Our sovereignty and duty to protect, operate in large part to safeguard that political integrity, economic security, and the health and welfare of our tribal nation. Nothing is more important or vital to the health and survival of our people, and each tribal nation retains and exercises those powers in order to enforce our internal criminal and civil laws. In pursuit of this, Bay Mills Indian Community has executed cross-deputation agreements, special law enforcement cards with the Bureau of Indian Affairs, and executed a formal agreement with the Chippewa County Jail nearby in order to meet the goals on behalf of our nation. However, we all know that tribal nations, although make up a small percentage of the population, continue to suffer disproportional rates of crime. And this is partly due to the fact that the history of violence against Native people is convoluted by the complex jurisdictional scheme that exists for tribal nations in the United States. The ruling in Castro-Huerta does little to solve these complex jurisdictional schemes and only contributes to this problem. It also adds an additional barrier for tribal nations to navigate and overcome. More so, the implications of Castro-Huerta go much further. and now cast doubt on any federal law that exists, including its application in Indian country. This may include permitting requirements and regulations, control of land or natural resources, and most of all, how tribal nations will continue to seek justice for our citizens. This ruling subsumes us to litigation to determine what applies and what doesn't. To bring up a concrete example that we are concerned about in the Great Lakes that could implicate criminal and non-criminal matters concerning businesses like extractive industries where tribal nations are targeted and exploited. In the Great Lakes region, both Bay Mills Indian Community and the Bad River Band of Lake Superior Chippewa are involved in litigation against a private corporation, Enbridge Energy, in which the Line 5 dual pipelines and proposed tunnel project may impact treaty lands and reservation lands. Because business practices should take into consideration the standards of tribal nations, without adherence to those set standards, tribal nations and development projects like this may lead to more violence and conflict and take advantage of land held by tribal nations for another's profit. What was once previously federal or tribal standards are now too questioned by Castro-Huerta. There has been one solution presented in which a tribal nation could look at another set of agreements with a local county to authorize the appointment of a qualified tribal prosecutor to assist in prosecuting state offenses committed within that tribal nation's reservation. However, that solution also raises more concerns because despite these agreements, a tribal nation would still continue to rely on their sovereignty for execution. And it does not come without the questions of if a state prosecutes a crime in Indian country, do they too pay for the cost? Do they pay for the jail fees? Does the tribe in seeking justice for their nation, how would each sovereign hold one another accountable? Furthermore, in order to pursue such an agreement as the one described, it would require a good working relationship with any party, which is not always determined by any set person. For example, in the state of Michigan, local county sheriffs and county prosecutors are carved out as an independent state actor and thus not subject to review or guidance by the governor or attorney general. In closing remarks, tribal nations have negotiated treaties with the United States of America and not the several states. The United States should not stay silent and let states set domestic policy with tribal nations. I humbly ask that the United States Congress develop a Castro-Huerta fix. Thank you, Madam Chair and Subcommittee, for the opportunity to speak and share these concerns with you today. I am available for further questions.
Thank you. Thank you very much, President Gravel. The chair now recognizes the Honorable Terry Gobin, who is the chair of the Tulalip Tribes.
Madam Chair and members of the committee, thank you for the opportunity to testify on the public safety crisis created by the Supreme Court's decision in the Castro-Huerta case. Shehelalos Sidsta. Shehelalos is my tribal name. Terry Gobin is my English name, and I proudly serve as the chairwoman of Tulalip Tribes. As one of the very first tribes to implement tribal jurisdiction that Congress restored to tribal nations in the 2013 VAWA, and as a tribe that has had to endure the harmful consequences of PL 280 in the state of Washington. Tulalip offers a unique perspective on how and why the court's decision will dramatically determine public safety throughout all of Indian country. The PL 280 is a law Congress enacted in 1953 during the termination era of federal Indian policy that divested criminal and civil jurisdiction from the tribes and allowed states to unilaterally assume this jurisdiction. Washington State PL 280 to accept jurisdiction over certain criminal and civil matters in the late 50s and early 60s. The Castro-Huerta case couldn't be more wrong with its underlying assumption that states will do a better job of protecting our children, or that by adding a layer of jurisdiction will do no harm. From a PL 280 tribe with decades of experience with the state having this jurisdiction on a reservation, We are here to tell you that there is great harm. It simply doesn't work. When Tulalip began exercising jurisdiction over non-Indians for domestic violence crimes under the Vawa tribal provision, children were present and physically harmed in over half the incidences we prosecuted. Yet, the state did not prosecute a single case against a non-Indian for these crimes against our children. Aside from the chaos and confusion that occurs when a state has jurisdiction over tribal lands, that jurisdiction is rarely exercised. And if the state does exercise this authority, there's often biased treatment, discrimination, and an insensitivity toward the tribal victim and their families. This leads to extreme distrust and no confidence in the law and justice, making prosecution in Indian cases extremely difficult and crimes go unpunished. Adding a layer to the state jurisdiction also becomes an impediment to the fulfillment of federal trust responsibilities. Cases and people fall through the cracks of this jurisdictional complexity as both state and federal law enforcement step back in favor of the other's jurisdiction. This is why we work hard to secure a partial retrocession of the jurisdiction granted to the state of Washington, but the decision injects uncertainty into PL 280. This is the state jurisdiction now resurrected, or could it be? Does the state now have jurisdiction without PL 280? Ultimately, the court's decision restricts the ability of tribal nations to seek self-sufficiency and build strong governments. And it disregards the connection between sovereignty and safety for Native children, threatening to obscure the critical work this Congress has done to restore our inherent right to protect our children. With the Supreme Court's consideration of Bracken versus Holland in the upcoming term, the opportunity for misinterpretations with regards to the inherent sovereignty of our tribal nation calls for the court's immediate correction. We desperately need Congress to act and correct the court's decision. And thank you again for taking this time to hear my testimony. Take a wait, seat.
Thank you very much, Chair Gobin. The chair now recognizes the Honorable Sarah Hill, who is the Attorney General for the Cherokee Nation. Attorney General Hill, the floor is yours.
Chair Ledger Fernandez, Ranking Member Obernolte, and distinguished members of the subcommittee. On behalf of the 437,000 citizens of the Cherokee Nation, I thank you for this opportunity to speak about the Supreme Court's recent decision in Oklahoma versus Castro-Huerta. As you know, the Castro-Huerta case arose on the Cherokee Nation reservation and involved the Cherokee child. The case was one of dozens the Oklahoma Attorney General brought in front of the High Court, hoping for an opportunity to overturn the landmark ruling in McGirt v. Oklahoma. McGirt was the result of a generational effort by tribal advocates to displace what Justice Gorsuch referred to as the rule of the strong with the rule of law in Oklahoma's Indian country. Castro-Huerta did not overturn McGirt, but it did issue a strong signal that despite clear federal legislation that preempted state jurisdiction over crimes by non-Indians against Indians in Indian country, as well as decades of prior court decisions, that we have not yet departed from an era where the rule of the strong can prevail. It is my belief, founded as it must be in faith in our democracy and our justice system, that McGirt will not be the high watermark. But the Castro-Huerta decision is certainly a retreat from the principal decision in McGirt, and that should give people who believe in tribal sovereignty and the rule of law some pause. In Castro-Huerta, the court went well out of its way to provide jurisdiction to Oklahoma over crimes committed by non-Indians against Indians. A new majority emerged in this case, and it demonstrated little regard for principles of federal Indian law that had been in place since Chief Justice John Marshall was on the bench. As Justice Gorsuch said in his dissent, the majority accepted the lawless disregard of the Cherokee sovereignty. This departure from well-established law represents a real threat to tribal sovereignty. The court essentially flipped the script on state criminal jurisdiction in Indian country. Instead of examining federal law for evidence that Congress had authorized state jurisdiction in Indian country, the court held that it only needed to examine federal legislation that might have preempted state jurisdiction. But the most troubling aspect of Castro-Huerta could be what it may portend for future cases and legislative efforts. I understand the desire to move forward on legislation to address this case. However, it is important to proceed thoughtfully and with a full understanding of any legal challenges such action might draw. We have seen what this court is willing to do, and that is something everyone should be thinking about as Indian country and Congress decide on next steps. As far as the current impact of Castro-Huerta, Cherokee Nation has been making extraordinary efforts post-McGirt to ensure public safety, and the day-to-day work of enforcing criminal laws on the Cherokee Nation's reservation is the same today as it was prior to Castro-Huerta. The costs of sustaining the large criminal justice system needed on the Cherokee Nation's 7,000 square mile reservation are substantial. The reservation's population is more than 500,000, many of whom are Indian, and contains several large municipalities, including a sizable chunk of the city of Tulsa. Under the leadership of our principal chief, Chuck Hoskin Jr., and our tribal council, Cherokee Nation has increased its spending on public safety by roughly $40 million. Congressional efforts to help alleviate these costs have been slow to make their way to the tribes most affected by McGirt. For example, in the FY22 omnibus, Congress appropriated $62 million for tribes directly impacted by the McGirt decision. That bill was enacted in March, but we are still waiting for BIA to allocate and release that funding. Increasing the flow of resources into the McGirt-affected tribes would be a welcome relief to Cherokee Nation and other tribes absorbing these costs largely on their own. I fear these costs will only continue to grow. Prior to McGirt, the nation had fewer than 100 criminal cases in any year. In the first year post-McGirt, we filed over 3,700 cases and are on track to beat that number this year. Our district court, attorney general's office, and marshal's service have all added significantly to their staff to meet this need. Additionally, with jurisdiction over non-Indians increasing due to recent amendments to the Violence Against Women Act, we are preparing for another jump in our caseload. Cherokee Nation had the highest number of charges filed under the expanded authority granted through VAWA 2013, and we expect a similar increase this time around. In the wake of the Castro-Huerta decision, we called for the governor of Oklahoma to come back to the table to end his anti-tribal agenda and move forward as we enter this chapter of concurrent jurisdiction. We stand ready to grow and continue the tribal state collaborations, such as cross-deputization agreements, that have proven so effective on our reservation. Our many successes at the local level highlight that tribal justice systems, far from being anything exotic or scary, are local and familiar and serve tribal communities with zeal and professionalism. Given an opportunity to flourish post-McGirt and post-Castro-Huerta, I have no doubt that tribal justice systems will continue to be a source of innovation and public safety throughout our nation. Thank you.
Thank you very much, Attorney General. We will now, I thank every witness in this second panel for their passionate testimony. I'm going to remind the members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask of the second panel. I will start by recognizing myself for 5 minutes. Honorable Chaudhuri, Honorable Ambassador, you spoke of the issues that arise because of the fact that tribes do not have, in essence, even when they have criminal jurisdiction, that they don't have full criminal jurisdiction. There are limitations on that jurisdiction, both in terms of the sentences that may be imposed, as well as the individuals against whom a tribe may prosecute. Can you elaborate a bit on why that makes it difficult to protect your people on tribal lands, and why it might be good to address that as we address a public safety package for Indian country?
Absolutely, and thank you, Madam Chair, and very much appreciated the witness testimony today, all of whom have called for action by Congress. Some of the limitations that I spoke of address sentencing limitations as well as jurisdictional limitations, and one of the main sources from it was another judicial usurpation of congressional power back in 1978, which called into question the capacity of tribal nations to prosecute properly criminal acts in Indian country. And that was a surprise to nations such as the Muskogee Creek Nation, whose roots of criminal justice systems existed before statehood of not just Oklahoma, but also Alabama and Georgia. But that case itself restricted jurisdiction to prosecute bad guys in Indian country, which we've fought for, and Indian country has universally fought for ever since. But since then, in trying to restore some of that jurisdiction, Congress has taken a very measured approach that has resulted in a bipartisan conclusion that more restoration of tribal authority is better. Some part of that measured approach included slowly ramping up sentencing authority of tribal nations, starting with a limit of 1 year, then later through the Tribal Law and Order Act, amping it up to 3 years. All of which was coupled with a robust due process protections for any defendants within Indian country. At each stage of the way throughout this trend of Congress empowering tribal nations, we've heard nothing but good results. We haven't heard the sky is falling result of bad actions coming from tribal court prosecutions. This is especially important to me. I have, in a previous life, served as Chief Justice of the Muskogee Creek Nation, and I can speak to the capacity of tribal nations. So sentencing limitations need to be addressed in Indian country, jurisdictional limitations. If we really want to keep people safe, whether they're native or non-native in Indian country, we have to empower local decision makers on the ground and the governments who have the greatest interest in protecting people.
Thank you.
That should appeal to both sides of the aisle.
Thank you very much, Ambassador. I now wanted to turn to Chairwoman Gobin. I think your testimony about the importance of, or the implications that you need to be able to protect your children is really key, and I thought that we heard that throughout, that theme throughout the testimony today. And can you elaborate a bit more on what it means as a tribal leader to know that you might be restricted from being able to respond to those cases where the children on your reservation, the children of your community are being abused and you cannot protect them, you cannot prosecute those crimes?
Okay, so this started out with the VAWA. When we first started to be able to prosecute non-tribals that were committing crimes against our women, some of the children that were in the room that actually got hurt really bad, they got beat during this time, there was no way to prosecute the crime against the child. And those children have you know, suffered a great deal, not only the verbal and the but physical abuse that was horrific, that they didn't get justice on having their portion of the crime go through a court system. It was devastating to the community. Some of these children are, you know, really suffering. They have to have that mental health, you know, counseling, but it's not right that those crimes never got to be going through the system. So it's you know.
Thank you very much. I did want to also ask the President, Kevin Keller of the Ogallala Sioux Tribe, about the comparison of the funds available at the state level to the tribal level, but I have run out of time. We are going to ask the witnesses to respond to written questions, and I will submit my written questions so that we may move on. I now recognize Ranking Member Obernolte.
Thank you to all our witnesses. It's been a very informative hearing so far. Mr. Chowdhury, I'll start with a question for you. So I want to thank you for coming to the table with a concrete solution. You've urged Congress to act, and I respect the position you've taken. are all of the 5 tribes of Oklahoma unified in their opinion of what Congress should do in this situation?
My guess is in any room full of tribal leaders, there are going to be different approaches to different problems. But when we talk about consensus, one of the themes we've heard repeatedly today is that this is an Indian country issue. We are, always happy to work with our sibling nations, and we're working towards solutions. But this is an issue that reaches far beyond Oklahoma. So I think even our Cherokee colleague mentioned the need for a thoughtful approach, and we respect the fact that she's calling for action, that Cherokee Nation's calling for action. But respectfully, one of the points that many of our colleagues raised is that the solutions are not new. They were vetted extensively by the Indian Law and Order Commission over 10 years ago, and the solutions are clear.
Right. Well, I mean, I think that's some of the challenges that we face here, right? Because there are over 500 federally recognized tribes, there's probably going to be 500 different opinions of exactly what Congress ought to do, including what is probably the minority viewpoint, but including the viewpoint that PL 280, is not such a bad thing, and that maybe that should be expanded. So, which is something I know that you would vehemently disagree with. So, how are we in Congress to determine what the right solution is, given the fact that we probably want to apply it equally across the country?
Thank you, sir. Excellent question. So I was very thankful to hear the chairwoman from Tulalip sound the alarm as to why tribal nations and public law 280 states have a deep interest in limiting the bad impacts of Castro-Huerta. So when you talk about consensus doesn't equal unanimity, and it's important to hear, certainly from all of Indian country, but if Congress ever waited to act for every tribal nation to sign on board with every proposal, Congress would never be able to uphold its treaty and trust responsibilities. So respectfully, we appreciate the dialogue from today to show the vast majority of sentiment in Indian country and urge Congress to consider appropriate action to uphold its responsibilities.
Thank you for the testimony.
Thank you, sir.
Ms. Gobin, I'd like to follow up on the chair's question because I'm very interested in the problems that you have illustrated with PL 280 and the situations where the perpetrators of crimes against Indians were not brought to justice as a result of that. Could you talk a little bit more about the situation you were discussing with the chair, where crimes were committed against children, the evidence was there, but those crimes were not prosecuted?
Yes, so that was where you have the 2 jurisdictions, you have the state and the feds, and neither one would take up the cases. And we have several that were on the books that did not get prosecuted. And we had conversations with, trying to get the state to do it, but also with the feds. Okay,
so why would, I think, opinions may differ about who has jurisdiction and who's going to do the prosecution, but, it's hard to believe that anyone would say crimes that have been committed against children, we have the evidence and that's okay. So, how did these cases fall through the cracks?
Well, I think with the state, they may have difficulty working with the tribes, and the feds, we would have thought that we could have moved those cases forward, but then they sit forever. And then we've had conversations on why aren't you taking this? So we did have those conversations, and we're hoping to move them forward in a faster way. But yeah, children were hurt, and there's a bias at the state. They don't want to take tribal cases.
Wow, that's stunning to hear that. I think that no matter what your opinion of Huerta is, we should all be unified in the desire to bring justice, for the victims of these crimes. So thank you for your testimony. I yield back, Madam Chair.
Thank you.
Thank you.
Thank you for your questions. The chair will now recognize the gentleperson from the state of New Mexico, Representative Stansberry.
Thank you, Madam Chairwoman. And I want to start by saying thank you to all of our tribal leaders and welcoming you to our committee and to Washington, D.C. It's great to see so many old friends and wonderful to have you here. And thank you to Chairwoman Ledger Fernandez and our ranking member for this important hearing. I want to start with my position on this issue, which is that I believe that this decision by the majority of our Supreme Court is a direct affront to tribal sovereignty and to tribal nationhood, and upends, of course, generations of settled law in the U.S. tribal relationship, hundreds of treaties, and is an affront to our Constitution, in which we recognize tribal sovereignty as inherent to our tribal nations. And so I strongly believe that we need to support the tribal nations who would like to see a legislative fix to this decision. But my concern and the question I want to direct to our tribal leaders who are here today and to those who are listening across our tribal nations in the U.S. is, how do we build a process at the congressional level to get to some form of consensus about the legislative path? I know some of the previous questions have touched on this. I served on a panel just last week with a couple of dozen tribal leaders asking the question, what should the legislative fix look like? And received at least 6 different answers based on 6 different legal theories and bases. I've heard more expansive responses that would like to overhaul and fix previous case law and statutory problems with how justice systems are supported in our tribal nations. I've seen more narrow fixes. And so my question for our panelists today is really a process question more than a substance question, which is there a need to seek a immediate fix that's reaffirms McGirt or addresses a fatal flaw before the end of this Congress, while we engage in a much more robust consultation process with the executive branch so that we can hear from all of our tribal nations, and sort of your thoughts about how we build a reasonable consensus on a legislative path forward. And I think, if it's okay, Madam Chair, just going in the order of the witnesses' testimony, starting with our Honorable Ambassador from Muskogee Creek.
Does that work for you, Madam Chair? If that does. Thank you so much, Congresswoman Stansbury. Always good to see you. So in the interest of time, I will say that there is no legislative language that we've put forward as a nation. However, there are proposals that we support that are intended to generate meaningful discussion, to have Congress signal its intent to uphold its responsibilities in short order. We are mindful of the potential for mischief and erroneous misapplication of the underlying rationale of Castro-Huerta in cases that go beyond public safety. Most importantly, and coming around the horizon, the Supreme Court's set to hear arguments in the Brackeen case, which, if the Supreme Court wrongly extends the rationale under Castro-Huerta, could be devastating for Native children throughout the country. So we want Congress to act quickly. In terms of legislative proposals that we would suggest or support, we not only support clarification in the public safety context, but to be clear, we also support a robust effort collectively to go after bad guys. And going after bad guys requires addressing sentencing limitations, jurisdictional limitations, and so forth. So we do believe action is needed now, and we support something that addresses things collectively. We don't call it a fix. We call it strengthening public safety issues in Indian country. Thank you so much for the question.
Thank you so much. And mindful that I actually have run out of time here with this. I'm going to submit this, Madam Chairwoman, as a question for the record to all of our witnesses. And as I stated, I would love to hear from tribal nations. We would love to hear from tribal nations across the country about how to build that consensus process. And the question about acting expediently before the end of this Congress and whether it's a both and doing something now as well as doing something more extensive. Finally, I just want to say that we are working very hard to get a real budget passed. We know there's going to be a short-term CR. We are hearing the need to get more resources to support tribal courts, to beef up DOJ and BIA law enforcement. And we know that this is a huge immediate need across Indian country. We stand with you, and we will be working very closely with our tribal nations to address this issue. Thank you, Madam Chairwoman.
Thank you, Representative Stansbury, for your questions and the answers. The chair will now recognize the gentleperson, Representative Rosendale. Thank you for being here.
Thank you, Madam Chair. Attorney General Hill mentioned some of this in her testimony, but I'd like to hear more from you, Ambassador Chowdhury, and AG Hill on the plans both your tribal nations have put in place to handle an increased caseload in your tribal courts pre and post McGirt. We'll start with you. You're right here.
Yes, sir. And as I said before, we have our Attorney General, Jerry Wisner, who works on the day-to-day implementation of McGirt, and any specific details she can follow up in the record with written testimony or here today if you so choose. But we have, like Cherokee Nation, amped up our budget from day one at Muskogee Creek Nation. Chief Hill formed a commission to look at all aspects of McGirt. From that commission, we increased our social services providers, our prosecutors, our judges. We now have double the number of judges that we ever had, servicing all the caseload that is coming through our system. We have more law enforcement on the ground and prosecutors. The numbers, our budget isn't as big as Cherokee Nation's, but our ramp up is probably proportionate, if not greater, since we were the very first nation to start implementing McGirt.
And AG Hill, would you have any further?
Yes. Yeah, I think just briefly, that $40 million represents a lot of different things. So from having one part-time criminal prosecutor who also handled the whole juvenile docket, which is one person could handle it. Now I have 7 full-time prosecutors. That's all they do. We opened up additional locations in Muskogee and in Jay, which are local areas, and are still looking to expand our district court system further, hired additional court judges, hired additional members of the Marshal Service. So basically, every part of our criminal justice system had to expand and grow in every way. That's just been an ongoing explosion in the criminal justice system. And one of the huge things I think that's worth mentioning is the detention budget. All of these people who are receiving these sentences have to serve that sentence somewhere, and those costs have really been skyrocketing. And I know that and also juvenile detention has been a huge issue for all of the tribes in Oklahoma who are affected by McGirt.
Right while I have you still speaking, AG Hill, can you also speak to how these plans have or have not changed after Castro-Huerta was decided?
Castro-Huerta did not, the way that we looked at it, it didn't affect tribal jurisdiction. So it didn't do anything to limit the number of cases coming directly to us. What it could limit is the number of cases coming to us under VAWA, because the Oklahoma Attorney General sent out a letter to some of the prosecutors in Oklahoma saying, you need to be referring these cases now to the state. That hasn't stopped those cases from coming to us. We're still seeing a pretty robust number of cases coming in from Indian country that are non-Indian crimes against Indians. So we haven't really seen a real big dip yet in that caseload. So we're still proceeding with our expansion plans as if nothing had changed with Castro-Huerta. Because as a practical matter, from our jurisdictional standpoint, the tribe's jurisdiction, it really didn't.
Okay, thank you. I was traveling around Oklahoma, it just so happens, recently, and met with several law enforcement agencies and was really pleased to hear about the cross-deputization and the collaboration that was taking place between the tribal and non-tribal law enforcement agencies. It sounded really, really positive. But I did find it troubling to hear about the different penalties that were imposed based upon tribal or non-tribal status and the location of the offense. So I don't know who's best suited. AG Hill, I'm thinking probably you. Could you expand on this for me and explain why it's so? And is there any plan to rectify or reconcile this difference?
Well, I think there's some mythology that gets mixed into all of that. I've heard on multiple occasions that if you get a ticket in one jurisdiction, it's one cost, and if you get a ticket at Cherokee Nation, it's a different one. And I'll chase it down, and it's just not true. There's a lot of local law enforcement that sort of have this mythology that tickets are much more expensive. And part of this is to get non-Indians to say, well, just go ahead and give me a ticket for the non-Indian court because it'll be cheaper, right? Even though this tribe has jurisdiction over them. And for the most part, our penalties are very consistent with what state penalties are. The only time that that's different is where our jurisdiction or our ability to assess that penalty is limited by federal law. So under the Indian Civil Rights Act, we simply cannot, for any crime, for one single crime, have a penalty longer than 3 years. And that there's nothing I can do about that from the tribal side.
Okay. Thank you, Madam Chair. I yield back.
Thank you very much for those questions and pointing out that distinction. That I think that's part of the issue that we were raising earlier, is the fact that we have, in essence, hobbled the ability of tribes to prosecute those crimes. And as we know, when there isn't the fear of prosecution and serious sentences, that then may lead to more reckless and criminal behavior. So thank you for raising that.
Sort of like our southern border.
So we're dealing with our internal borders of the tribes right now, and love to focus on that exclusively at this in this committee. So I want to thank our witnesses for their valuable testimony and the members for their questions. Now I would like to transition to our final panel of witnesses for today. Once again, I'm going to remind non-administration witnesses that they are encouraged to participate in the Witness Diversity Survey created by the Congressional Office of Diversity and Inclusion. Witnesses may refer to their hearing invitation materials for further information, and our committee rules. Oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down and will turn orange when you have 1 minute remaining. I recommend that members and witnesses join remotely lock the timer on their screen. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will allow the entire panel to testify before we begin the question portion of the hearing. Once again, we moved the hearing to 11 so we wanted to see if we could get through the testimony before votes were called. We are hopeful we will be able to move through as much as possible before votes are called. The chair will now recognize, if we're ready, will now recognize Ms. Mary Catherine Nagel, who is counsel for the National Indigenous Women's Resource Center. We're getting ready quickly.
Madam Chairwoman and members of the subcommittee, ranking member, I am honored to serve as counsel to the National Indigenous Women's Resource Center, a national nonprofit working to end domestic violence and sexual assault against Native women and children. Today, our Native women and children face the highest rates of violence in the entire United States. The reasons for this epidemic, however, are no mystery. In 1978, the United States Supreme Court took away the inherent jurisdiction of our tribes to protect our own citizens on our own lands. And 2 months ago, the court gave that jurisdiction to states. The majority opinion in Castro-Huerta erroneously ignored Congress's passage of VAWA 2022, and the court discarded Congress's considered judgment. The crime underlying the court's decision in Castro-Huerta involved non-Indian abuse against an Indian child on tribal lands, a crime that as of October 1st, 2022, tribal nations will once again be able to prosecute because Congress restored this jurisdiction to tribal nations, not states. In restoring this jurisdiction, Congress recognized that no sovereign has a greater interest in protecting Native children than their own tribal nations. Indian law scholars have noted numerous problems with the judicial underpinnings of the opinion in Castro-Huerta. It misconstrues the plain language of the General Crimes Act, it violates the Constitution's separation of powers, and disrespects Congress's exclusive authority to legislate over Indian affairs. But most concerning is the fact that it obviates the connection between tribal sovereignty and safety for Native women and children. The consequences of Castro-Huerta as they relate to safety for Native women and children have already proven to be bad. Because of Castro-Huerta, our Native women and children will now have to rely on their state and local governments to protect them, and governments that have until now have failed to do so. The NIWRC is already receiving reports that individual United States attorneys' offices are implementing policies to defer prosecution of crimes committed against Indians on tribal lands to state law enforcement, based on a flawed reading of Castro-Huerta. Nothing in Castro-Huerta invites the Department of Justice to distance itself from its treaty, trust, duty, and responsibility to safeguard the lives of our women and children. But as we've witnessed with PL 280, the Kansas Act, and the few other instances where Congress has granted states jurisdiction over crimes against Native victims on tribal lands, such a grant of jurisdiction to states inevitably results in a decrease in federal prosecutions, a decrease in resources dedicated to the crime, and an increase in violent crimes against our Native people. For instance, after Nebraska acquired this jurisdiction through PL 280, the United States Commission on Civil Rights reported that all the tribal nations in Nebraska were told the state simply, quote, did not have enough funds to maintain stationed deputy sheriffs on their reservations. I wish I could say that state and local governments have historically prioritized the protection of our Native women and children, but they have not. In Bighorn County, the state county with the highest rates of missing and murdered Indigenous persons in the entire United States, the state of Montana has done nothing to address the fact that an entire sheriff's county's office repeatedly refuses to investigate the innumerable homicides of Native people within the state's jurisdiction. Kesara Stops Pretty Places, Allison High Wolf, Selena Not Afraid. The list goes on and on. In North Dakota, local and state law enforcement did not search for Savannah Graywin's body when she went missing. She was murdered in Fargo, North Dakota, but the Fargo police refused to look for her. It was her friends and family who organized the search party. State law enforcement did nothing. In Alaska, a PL 280 state with the highest rates of violence against Native women, Native victims of violent crimes who call 911 wait days and days for the arrival of a state trooper. Oftentimes, children and family members have to guard the crime scene until state law enforcement finally arrives. Native children are their first responders. In Wyoming, Native people comprise 3% of the entire state's population, but they are 21% of the state's homicide victims. Oklahoma, the state that asked this court for this jurisdiction, fares no better. In 2017, the Urban Indian Health Institute found that Oklahoma ranks in the top 10 of states with the highest number of MMIWG cases, and Oklahoma City ranks in the top 8 of American cities that fail to properly record and investigate MMIWG cases. The decision in Castro-Huerta, sadly, has nothing to do with what's best for Native victims. It is an outcome-determinative decision fueled by one governor's multi-million-dollar PR campaign to overturn the court's prior decision in McGirt. But when the dust has settled and the rhetoric has calmed down, it will be Native women and children who pay the price. We are asking Congress to take action and address the crisis created by Castro-Huerta. Thank you.
Thank you very much for your testimony. The chair will now recognize Ms. Bethany Berger, who is the Wallace Stevens Professor of Law at the University of Connecticut School of Law.
Thank you, Madam Chairwoman, for the opportunity to speak with you, and thank you for your attention to this important issue. My testimony will focus on how Oklahoma versus Castro-Huerta violates both congressional original intent and 200 years understanding and practice. Federal jurisdiction crimes non-Indians against Indians was the first and most important of Congress's Indian country jurisdiction statutes. Congress created that jurisdiction in 1790, but did not extend that jurisdiction to Indian country crimes generally until 1817. That's because non-Indian crime threatened the peace of the nation, treaties with tribal nations, and states could not be trusted to punish the offenders. In 1832, the Supreme Court decided Worcester v. Georgia, a landmark decision in the battle between state, tribal, and federal power. The court held that Georgia, in prosecuting 2 non-Indian missionaries on Cherokee land, violated not only the Cherokee treaties, but also Congress's statutes regarding crimes in Indian country. 2 years later, Congress reenacted those statutes, incorporating that understanding of state exclusion. The language of those statutes has remained the same, the core language from 1834 to today. authority has increased in Indian country since 1834, states never got jurisdiction over crimes involving Indians. In 1886, the Supreme Court affirmed that this was because the federal trust responsibility prevented jurisdiction because states were often the deadliest enemies of Indian people. Although that case involved an Indian defendant, the court in 1913 affirmed that this reasoning applied even more to cases where non-Indians were committing crimes against Indians. In 1946, and again in 1959, the Supreme Court stated that lacked jurisdiction over non-Indian against Indian crimes. 20th century statutes make this even clearer. In at least 9 between 1940 and 1994, Congress explicitly granted states jurisdiction over offenses by or against Indians in Indian country. Oklahoma versus Castro-Huerta suggests that language in 9 statutes over 5 decades was either merely Congress spinning its wheels or acting because it was not sure of the law. But that's not how we interpret statutes, and the Supreme Court once recognized that. Of course, those statutes were from an earlier time when Congress thought that state jurisdiction might improve public safety in Indian country. Today, as you've heard, it's not true. In fact, it's the opposite. State jurisdiction makes Native victims less safe. And the federal government has recognized that, requiring tribal consent before states expand jurisdiction, encouraging and permitting states to retrocede the jurisdiction they already have, and expanding tribal accountable jurisdiction in its stead. In Oklahoma, Castro-Huerta, the Supreme Court ignored all of this history, all of these congressional actions, all of these Supreme Court statements. It also ignored the accepted rules for preemption in Indian affairs, unsettling jurisdiction in civil as well as criminal matters. Instead, it accepted Oklahoma's invitation to make up an interpretation of its own, divorced from 200 years of history and understanding. This is bad law and it's bad policy, and thank you for considering action to fix it. Thank you very much.
Thank you very much for your testimony. The chair will now recognize Ms. Bethany Berger. The chair will now recognize Ms. Carol Goldberg, who is the Jonathan D. Virat Distinguished Professor of Law at the University of California School of Law, as well as the Chief Justice for the Court of Appeals for the Wallapai Tribe and the Chief Justice for the Court of Appeals for the Pechanga Band of Indians.
Thank you very much, Madam Chairwoman, Ranking Member, for this opportunity to testify. My name is Carol Goldberg, and I've been researching and writing about a federal law known as Public Law 280 for nearly 50 years, in addition to other aspects of federal Indian law. And I can say with quite emphasis that Castro-Huerta got the relevant law entirely wrong. I'm going to focus my testimony on Public Law 280 because Castro-Huerta actually made a mess and a mockery of that statute. That statute should have precluded state jurisdiction, even if the Federal Indian Country Crimes Act, Section 1152 of the Federal Criminal Code, did not. Now, why should Public Law 280 have produced a different result in Castro-Huerta? Well, as you heard from the chairwoman of Tulalip, this law was enacted in 1953. It gave 6 states jurisdiction over crimes committed by or against Indians in Indian country. It also created a very specific mechanism for any other state to opt in to the same jurisdiction. And in 1968, that same opt-in mechanism was amended to require consent through a vote of the affected Indians. Oklahoma was neither one of the 6 states named in Public Law 280, nor has it ever invoked the mechanism of Public Law 280 to acquire jurisdiction over crimes committed by or against Indians. In 1971, in a case called Kennerly against the District Court, the United States Supreme Court required the state of Montana to use the mechanism of Public Law 280 to acquire jurisdiction, even though the affected tribe had made an agreement with the state to allow jurisdiction. Castro-Huerta assumes that if the tribe's interests aren't hurt by piling state jurisdiction on top of federal, state jurisdiction should be fine. But if that were true, the Kennerly decision would have come out the other way, because the tribe in that case had actually made an agreement. But instead, in Kennerly, the US Supreme Court insisted on strict compliance with Public Law 280 for a variety of reasons, including respect for Congress and for tribal sovereignty. I also explain in my written testimony why Castro-Huerta's attempt to explain away the inclusion of crimes by non-Indians against Indians in Public Law 280, their argument doesn't hold water. Basically, there is no evidence whatsoever in the legislative history of Public Law 280 that Congress ever doubted the preemptive effect of Section 1152, which Professor Berger has already explained. Congress believed that further legislation was necessary to allow state jurisdiction over crimes committed by non-Indians against Indians, and Public Law 280, with its mechanism, was that law. Castro-Huerta also reflects a misguided policy choice regarding Indian country criminal justice. My research, empirical research on Public Law 280 shows that under that statute, where state jurisdiction does apply, it has produced biased treatment against Indian victims and witnesses in state courts, as well as biased treatment favoring non-Indian perpetrators in state courts. The unanimous, bipartisan 2013 report of the Indian Law and Order Commission, on which I was privileged to serve, produced policy recommendations pointing in the exact opposite direction from the policy choices implicit in Castro-Huerta. We recommended moving criminal justice authority closer to Native nations and away from both federal and state governments. This was unanimous and bipartisan, Republican as well as Democratic appointees. And I want to stress, as have others, that tribes in Oklahoma are not the only ones affected by Castro-Huerta. Dozens of other states have either failed to opt into Public Law 280 or, as with Tulalip, their previously imposed Public Law 280 jurisdiction has been retroceded or returned to the federal government. Castro-Huerta would introduce state jurisdiction without the mechanism of Public Law 280, and that is just wrong. Not a single tribe has consented to state jurisdiction since 1968. But if any tribe today truly wants this state jurisdiction that Castro-Huerta spoke of, it can go ahead through the processes established by Public Law 280. The poor reasoning of that opinion also puts Native nations throughout the United States at risk in a variety of realms, as among others, the representative from Bay Mills Indian community elaborated. So thank you very much for this opportunity to testify. I look forward to answering any questions you may have.
Thank you, Professor and Associate Justice Goldberg. The chair will now recognize Honorable Matthew J. Ballard, who is the District Attorney for Oklahoma's District 12. You are now recognized for 5 minutes.
Thank you, Madam Chair, Ranking Member. My name is Matthew Ballard, and it's my honor to appear before you today as the elected District Attorney for Oklahoma District 12, and to give voice today to the Native American victims who have been given hope as a result of Castro-Huerta. My purpose today is to provide real-world examples of people, of Native American victims who have benefited from Castro-Huerta, who Castro-Huerta served as a beacon of hope that they might one day get justice. These are more than anecdotes. These are real people in my community. These are my constituents. They're my neighbors. They're my friends. We go to the same church. We send our kids to the same schools. The people I'm talking to you about today are from my community. 2 years ago, the law enforcement community in Oklahoma was thrust into chaos when the Supreme Court determined that 2 million Oklahomans resided on reservations that had never been disestablished. To give you an idea of that, there are 14 states in this nation with populations smaller than the number of Oklahomans living on Indian reservations. So what did that look like in my district? In my district, we saw hundreds of cases being dismissed. We saw dockets that were filled of 200, 300, 400 different cases that we knew that we were going into court and those cases were going to be dismissed. Those victims were never going to see justice. I had multiple times where I walked into my victim advocates' offices. These are people who exist, who do their job every day, building trust with victims, telling victims that, assuring them that we will seek justice for them, who build relationships with victims. As a result of the phone calls they were making, they spent hours calling victim after victim after victim just to notify them that their case was being dismissed. On multiple occasions, I walked in and found my victim advocates in tears. It was so overwhelming. At one point, I told them, go home, call it a day. And they looked at me and they held up a list and they said, not until we go through this list. It's on us to call every victim on this list and let them know. They can't hear it from social media. They shouldn't hear it from the news. They need to hear it from us because they trust us. And Native American victims were bearing the brunt of the McGirt decision. Only federal jurisdiction existed where non-Native victims were involved. In the Eastern District, the federal U.S. Attorney's Office determined that their threshold for filing cases was serious bodily injury. If a case didn't involve serious bodily injury, it was a decline. So let me tell you about some of the victims and how that impacted them. Let me tell you about Kayla Dobbs. The day the Cherokee Reservation was recognized by the Oklahoma Court of Criminal Appeals as having not been disestablished, that night, Kayla Dobbs was at the Iron Horse Saloon in rural Oologah, Oklahoma. While she was there, she ran into an ex-boyfriend who was there with a female acquaintance. While she was on the phone and with her back turned, she was hit in the back of the head, knocked to the ground, pepper sprayed in her face. Rogers County deputies were dispatched to the scene. They showed up and they had to ask the question, is anyone here Native American, to determine whether they even had jurisdiction to investigate. Kayla, our victim, was Native American and her assailant was not, so the deputy quickly realized that he didn't have jurisdiction, it was solely federal. As a result, he called the FBI office. The FBI office at 1 o'clock in the morning about a bar fight and was told the FBI wouldn't come out. That's what we're seeing in Oklahoma. But let me tell you about now a case involving hope. Let me tell you about Katrina West. Katrina's son was violently murdered along with his cousin. It was later determined that her son and his cousin were Native American. And the case, our state case, was dismissed. But we got to know Katrina through my office, assuring her we were going to seek justice. Well, we told her federal courts did refile, and she came to us upset that they'd offered a 17-year sentence. Mind you, that the minimum sentence in Oklahoma for a single homicide is a life sentence, which is calculated at 45 years. She came to us upset, and we explained unless Castro-Huerta came out in our favor, her son, there's nothing we could do. The day Castro-Huerta came out, she called me in tears. My victim advocate came in and said, she's on the phone. I took the call. She was tearful, and she said, Matt, does this mean what I think it means? Does it mean you can refile your case? I told her that it did. And through her tears, she said, thank God, we've refiled that case and we're going to seek justice. And that is what Castro-Huerta provided to us in the state of Oklahoma, was the opportunity to go out and seek justice for our Native American victims. Thank you to the panel.
Thank you very much for your testimony and the stories of the victims. The chair now recognizes Mr. Mithun Masingani, my apologies, Mansingani, who is a partner at Lahotsky Keller, for 5 minutes. Thank you.
Chairwoman Fernandez and Ranking Member Obolnoti, I want to start by thanking the House Subcommittee on Indigenous Peoples for inviting me to speak. By way of background, I'm a partner at Lahotsky Keller in our Oklahoma City office, where one of my specialties is federal Indian law. Prior to returning to private practice earlier this year, I served for 5 years as the Solicitor General for the state of Oklahoma, where I litigated several important federal Indian law cases, including the case that is the topic of today's hearing, Oklahoma v. Castro-Huerta. My testimony today represents my own personal views and not those of my current or former employers. In Oklahoma v. Castro-Huerta, the Supreme Court held that the federal government and the states have concurrent jurisdiction to prosecute crimes committed by non-natives against tribal members in Indian country. Those crimes are within federal jurisdiction because a federal statute, the General Crimes Act, extended federal law into Indian country. And they are within state jurisdiction because nothing in that federal law said that the federal government's jurisdiction was exclusive or otherwise preempted state jurisdiction. This particular case concerned the prosecution of a foreign national who severely neglected, to the point of torture, his daughter, who was a member of an Indian tribe based in North Carolina. The crime occurred in the newly recognized Cherokee Reservation in eastern Oklahoma. The state intervened in this abuse to protect the Native American child from a non-Native abuser, and that is what this case was always about. Do states have jurisdiction within their own borders over people who are not members of a tribe, including those non-natives who hurt tribal members? Or put another way, the question is, did Congress ever pass a law saying that states have no power to protect tribal members within state borders when those tribal members are abused by non-natives within the state? The Supreme Court, following a close reading of the laws Congress has enacted and its past precedent, said states have jurisdiction to punish these crimes. I go over all of this because I think it's important to keep in mind what this case is about and to read the Supreme Court's decision for what it says. So while this hearing is about the decision's impact on tribal sovereignty, we should remember that the decision in Castro-Huerta is, first and foremost, a ruling about state sovereignty. It says that state borders matter and that state sovereignty matters, which under our Constitution stands for the common sense proposition that states have jurisdiction within their borders unless Congress validly says otherwise. The decision therefore gives meaning to Congress's choice to create states like Oklahoma or New Mexico or California and to establish their borders to include lands that are Indian country. And it correctly observed that Congress never has said states lack jurisdiction over non-Indians within their borders when those persons commit crimes in Indian country. The court's opinion, of course, was not silent on the issues of tribal sovereignty. But what it said was that the exercise of state jurisdiction here would not infringe on tribal self-government because a state prosecution of a crime committed by a non-Indian against an Indian would not deprive the tribe of any of its prosecutorial authority. And I think I just heard Attorney General Hill agree with that idea, that this doesn't affect tribal's prosecutorial authority. And a state prosecution of a non-Indian does not involve the exercise of state power over any Indian or over any tribe. The only parties to the criminal case are the state and the non-Indian defendant. Nor was this opinion silent on the role of the federal government. The court held that both the states and the federal government can prosecute these crimes, providing a dual layer of protection. State prosecution would supplement federal authority, not supplant federal authority. But the state being forced to turn a blind eye when non-Indians abuse Indians doesn't serve anyone's interests. Not state interests, not federal interests, and not tribal interests. Some have suggested that Congress try to pass a law overturning the result in Castro-Huerta. I think that would be ill-advised. As the Supreme Court stated in its opinion, such a rule would require states to treat Indian victims as second-class citizens. And I know from my experience in Oklahoma, in which the vast majority of Indian country now lives, that when states are hobbled in their ability to protect Native victims, the unfortunate results are all too predictable. Thank you, and I welcome any questions the subcommittee members may have.
Thank you very much for your testimony. Today, we will now go to member questions, reminding the members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they wish to ask the witness. I will start I will start by noting that votes have been called. Because of the time that we have, we are hopeful that we will be able to get through questions before we each have to go vote, but we might do a little tag team. I'll start by recognizing myself for 5 minutes. Ms. Nagel, you described in quite an impactful way the manner in which women and children and other persons have been harmed, and there haven't been prosecutions of them. We also heard some very powerful testimony about others in Oklahoma who might have not faced prosecution. Can you describe how you believe coming up with a congressional response to Castro-Huerta can address the issues that you raised in your testimony?
Yes, thank you so much, Madam
You're not on yet.
But okay,
There
thanks.
we go.
So one thing I just want to address very quickly is that the NIWRC and tribal nations have been working to protect Native victims long before July 9th, 2020. Oklahoma's professed commitment to safety for Native victims really began on July 9th, 2020, when they discovered that it would serve their political interest in their attempt to overturn McGirt to say they care about Native victims. In the state of Oklahoma, organizations like Native Americans Against Violence advocated for decades, begged the state of Oklahoma to put Native women on state-recognized committees targeted to addressing domestic violence so that they could have a say in how the state would disperse resources or prosecute cases of violence against Native victims. And the Attorney General and Governor for decades refused to put Native women on those committees. We have numerous examples in Oklahoma of Native victims not receiving justice under state jurisdiction. And at the end of the day, I'm sure individual district attorneys can come up with individual Native victims they've sought out and convinced to say that they're pro-state jurisdiction and anti-tribal jurisdiction. But across all of Indian country and all of the United States, what the data shows, what we know to be true, is that no one has a stronger interest in protecting Native victims than tribal nations. And when it's left up to the state, sure, you will find instances where one county attorney or district attorney does prosecute that case, but by and large, statistically, our Native victims are left without justice when they're told, go look for justice at the state. I could guess as to the reasons, but I think at the end of the day, and I know Ranking Member asked a question earlier, it is hard to fathom why a state wouldn't prosecute a crime against a Native victim. I think it comes down to allocation of resources, and it just hasn't been a significant priority. But it is a priority for tribes. And the public safety crisis post-McGirt was really the fabrication of the failure and refusal of local county sheriffs and attorneys to actually collaborate with attorney generals like Jerry Wisner, who's sitting here from Muskogee Creek Nation, or Sarah Hill at Cherokee Nation. Our tribes stand ready to prosecute these cases. And one other thing I will just add, as the Supreme Court held in United States versus Cooley, there is no it's a false narrative to say that you can't investigate a crime that you see happening because you might not have jurisdiction to prosecute. As the Supreme Court reminded us in United States versus Cooley, all sovereigns have a right, if there's reasonable suspicion that a crime is being committed, to detain. You may not be the sovereign that can ultimately prosecute, but you can intervene when a crime is being committed and then call the feds or the state or the tribe or whoever needs to be called to address that crime. And so a lot of the public safety crises that we're hearing about are really just designed to serve a particular political purpose.
Thank you very much. I also wanted to have a bit more testimony with regards to the concerns with how this might overflow into civil jurisdiction. So I believe that would be, I'm going to ask that of Ms. Bethany Berger. Can you discuss a bit more about your concerns about whether, even though this began, and I think that this is the issue, is it began in one jurisdiction, but its implications across the country, across all the many tribes in all of our states, is broader, and so that's what we are looking at. Ms. Berger, can you address why you're concerned about that?
Sure. I mean, so it's always been the understanding that when the federal government comes in and asserts jurisdiction to itself, that preempts state jurisdiction. In fact, understanding has been even broader that when the federal government doesn't directly impose jurisdiction, but acts in a field, that preempts state jurisdiction. That comes from that old deadly enemies relationship. And what McGirt did is it said, contrary to what the Supreme Court has always said, you have to expressly preempt state jurisdiction. So this allows, potentially, I hope not, allows state jurisdiction over family law, over tax law, over numerous fields that has never been allowed.
Thank you very much. Finally, Ms. Carol, I wanted to also get more from Ms. Carol Goldberg about the Law and Order Commission. You spoke much about why you believe the decision was wrong, but also you quickly touched on the fact that your work on the the Indian Law and Order Commission in some ways sets the path to where we need to be headed. I will leave that for answer to a written question and will now recognize the ranking member for questions.
Well, thank you to all of our witnesses. It's been a very interesting panel. Mr. Ballard, I'm sure you were listening during the previous panel. There were some pretty emotional testimony about cases where declination of prosecution had occurred in Indian country and resulting in denial of justice to victims. Do you believe that non-prosecution of cases with Native American victims is a widespread issue?
I can only speak. I can speak to my district, and I can tell you that prosecution of cases and standing up for victims is something that I feel very passionately about. These are our Native American victims. They're members of my community. I have 3 nieces who are Native American. We live together, we work together, we worship together, and at the end of the day, I feel very passionately that we seek justice for every victim. And so, no, I don't believe that it is widespread. I believe that in my office, we absolutely seek justice for every victim. I can tell you it was devastating to my staff to be told that we couldn't prosecute cases, and the cases that we believed in, that we had built relationships with victims, that we had persuaded victims to trust us, to come forward with horrible stories and place that trust in us. It was so very difficult to see those cases dismissed.
Well, thank you very much for your passion. Mr. Mazzagani, something that you said in your oral testimony really stuck out to me. You were talking about how allowing states' jurisdiction to prosecute crimes committed on Indian country provided, I think your exact words were, a dual layer of protection for victims. But there were multiple members of the previous panel who had exactly the opposite opinion, that said that with so many different agencies having jurisdiction, that crimes could fall through the cracks. So I wanted to give you an opportunity to expand on your opinion that the dual layer of protection idea is the correct one.
Sure, and I think we heard from the Department of the Interior representative that the federal government will in fact not be pulling back resources. So I think we can be confident in that dual layer of protection. And to the extent that there are states out there that don't want to exercise this authority, then nothing changes because the federal government continues to have jurisdiction under Castro-Huerta, and this wouldn't increase any public safety problems. I think the idea that if there is another sovereign that can prosecute, that only complicates and makes things worse, is not the right one. And we know that, including from the tribal perspective. When the tribal governments were given jurisdiction under the Violence Against Women Act statutes, they were given it concurrently with the federal government. But nobody was arguing that that would make Indian victims less safe because now there's a second sovereign that can prosecute. It was always argued that it would make Indian victims more safe. So I think that belies the assertion that whenever you add another sovereign, it just makes things worse, not better.
Right, thank you. Well, I want to thank all of our witnesses. This has been an incredibly informative hearing. Hopefully this is the first of several hearings that we'll conduct as we try and craft a solution to this issue. But I want to thank everyone for focusing on the need to provide this justice and the need to provide resolution to victims and their families. I think that should be our guiding principle. Thank you, Madam Chair. I yield back.
Thank you, Ranking Member. The Chair will now recognize the gentleperson from Guam, Representative San Nicolas.
Thank you so much, Madam Chair. I apologize for my tardy presence in the hearing. I had the original scheduling for 1 p.m. On my calendar. I didn't realize that it was moved to 11 a.m. And so I will definitely be catching up on the transcriptions of the previous testimony. But I was able to dial in just in time to listen to Mr. Mazzagani and the case he was making for somehow dual sovereignty in a judicial system being a good thing. I really can't see how that makes much sense. It's like saying that having a plethora of authority to be able to determine a judicial process is somehow something that's going to be better for the process. And really, when you're talking about due process and when you're talking about the sovereignty of the tribal nations, you really cannot serve two masters, and you cannot have two systems that claim to be espousing one form of justice. We need to, in my opinion, Madam Chair, respect the history, respect the trajectory, and respect the sovereignty of the tribal nations and what we've extended to them over the years. I believe that the ruling of the Supreme Court to allow for states to also be able to interject into the the need for judicial proceedings onto tribal in the face of tribal sovereignty, I think is just something that's incompatible with the word sovereignty. And so I would very much like to familiarize myself more with the testimony that I was unfortunately unable to capture earlier. But I will go ahead and yield my time back to you, Madam Chair, if there was anything you wanted to elaborate based on any of the sentiments I've shared.
Thank you very much for your comments and your apt description of multiple masters. I am concerned about issues where you have overlapping jurisdiction. We are all, I think, very comfortable with the federal state or federal tribal relations. I will say I worked in tribal state relations for 30 years, and whenever you have dual taxation, it's an area that we worked in a lot because it doesn't work when you have overlapping jurisdictions that are not federal, at the federal level, federal, tribal. And so I think that is one of the concerns that we will be addressing. We also, I think, statistically know that the issue of murdered and missing Indigenous women and people is precisely because of the fact that there hasn't been clear jurisdiction and the ability of the tribes to prosecute. So these are issues. I really do want to thank our two witnesses for the work, for the perspective that they gave, which was important for us to hear. So I thank you very much for that. I thank you for your commitment to the victims of crime in your jurisdiction and your dedication to them. And with that, we are at the end of our hearing. And so are there any other, okay, great. So not great, but just because we got to go vote, we actually were able to do this. I very much am sorry, Representative, that we did want to make sure we thought it was important that we have our hearing on this decision, that we move forward because it does have such great implications, and we have a very long series of votes this afternoon. So I stated before, the members of the committee may have some additional questions for the witnesses, and we will ask you to respond to those in writing under Committee Rule 3. Members of the committee must submit witness questions within 3 business days following the hearing, and the hearing record will be held open for 10 business days for these responsive. If there is no further business, without objection, the subcommittee stands adjourned.